Okay, let's talk about in the interest of justice. It's a legal principle ensuring fairness, equity, righteousness in judicial decisions, allowing judges to exercise discretion and reach a just outcome. It authorizes actions such as transferring venues or dismissing cases that might otherwise lack strict procedural grounds but are necessary for fairness. Definition: a subjective standard emphasizing the decision should be equitable, impartial, and balanced. Judicial discretion allows courts to override rigid technical procedure rules when they would cause an unfair result. Usage: often invoked to justify dismissal of cases, change of venue, or specific sentencing recommendations, and I often use it for dismissal of cases. Purpose: ensure the administration of justice is not just technically, but aligns with public good and fair treatment for all parties. The term is often used as a final argument to ensure the court acts rightly when the standard legal procedures fail to produce a fair result, which that's what a lot of you are dealing with. Okay, so there's a lot to be said about in the interest of justice, but the main thing to understand, it's a legal principle. So it must be abided by, okay? So that's why I used it in my closing statement. In the interest of justice, justice must be served. Okay, so I put in penalties for violating the Interest of Justice Act. Violating obstruction of justice laws, often prosecuted as a felony, can lead to significant penalties, including 1 or 3 years of state-level offenses in Illinois, and federal cases up to 30 years. Other penalties include fines up to $25,000 or higher for federal, and up to $500,000 for money laundering-related obstruction, permanent criminal records, and forfeiture of assets. Forfeiture of assets. Key details regarding obstruction and related violations: Illinois State Violation 70 ILSCS 5/31-4. Actions like destroying evidence, providing false information, or inducing false testimony are Class 4 felonies, including 1 or 3 years in prison and up to $25,000 in fines. Federal violations: 18 U.S.C. 1512, obstruction, harming, or influencing witnesses or evidence in official proceedings can lead up to 30 years in prison. Financial and other penalties beyond prison and fines: offenders may face probation, court-mandated fees, and reimbursement for incarceration costs. Specific statutory violations: knowingly falsify reports or refusing to produce evidence. I tried to get a police report and they told me I had to file a FOIA report. That's evidence. That's clearly under the color of the law, not in the public interest, in the interest of the bar. That procedure is totally unnecessary. They could have just made a copy and gave it to me, or said, hey, you can get it off the internet. Specific statutory violations: knowingly falsifying reports or refusing to produce evidence. 15 U.S.C. 1825 can lead to fines of $5,000 and up to 3 years in prison. For lawyers specifically, violations can lead to professional disciplinary charges, which may impact their standing before the court. And if you people remember from my other videos, I told you your lawyer failure to inform you, let alone review with you the rules of professional conduct, their legal obligations, responsibilities to you in a court of law is deprivation of rights. All right, deprivation of rights. you're the judge, and the opposing party should be citing your attorney for ineffective assistance of counsel. Since they don't, that's violating the rules and the codes, which leads to conspiracy against rights under the color of law. Okay, all you got to do is read the rules and the codes, and it'll click. It'll come together, because reporting misconduct is mandatory in both the rules and the codes. And so if one person violates the rules and the codes, it's mandatory for the other parties to report, and if they don't, that creates the conspiracy. And everybody's violating the rules and the codes, so nobody's reporting each other. Simple as that. Okay. So people sometimes, I was talking to Mr. Ritchie, and he said there was laws I mentioned that he never heard of. And I have a tendency to do that with people that actually haven't read these laws. So I was just pointing them out, and he didn't have access to the internet, as he said, but that's all I do is read the laws off the internet. So in a lot of the videos when I speak, in a lot of the verbiage, the language that I use are legal terms. Each title for every video is a legal term. And I just read you the definition of those legal terms like I'm doing now, in the interest of justice. And any obstruction of justice, go to jail and lose everything you got. I'm just showing you the law. Okay, so that statement I said that anybody could use that I wrote, in the end I put, in the interest of justice, justice must be served. Your failure to do so would add to this conspiracy against rights under the color of law. Pretty much says it all. Okay, people, my apologies to so many of you. I started so young reading a lot of this stuff, you know. When I first read the Rules of Professional Conduct and the Code of Judicial Conduct back in 1979, it was easy to put together this conspiracy against rights under the color of law. That's where it started, just me reading it. The rules and the codes, they're interconnected. It's a symbiotic relationship. You know, they live off each other. They feed off each other. When one goes down, so does the other. I even tried to explain to people when it comes to the letter of the law and the spirit of the law. It's a symbiotic relationship. The letter of the law clearly states that what you read must be done word for word to the letter, and the spirit of the law, so that we all see, say it, hear the same thing, and there's no misinterpretation. That's why I read this to you word for word to the letter. Disqualification of justice, judge, or magistrate judge. Any judge or magistrate judge of the United States shall disqualify himself in any proceedings which his impartiality might be reasonably questioned. He shall disqualify himself in the following circumstances: where he has personal bias or prejudice concerning a party, or personal knowledge of disputed evidentiary facts concerning the proceedings. When private practice, he served as a lawyer in the matter of controversy, or who shown previously practiced law, served such an association as a lawyer concerning matter, a judge or such lawyer has been material witness concerning it. Okay, so there's a lot of different things that can disqualify a judge, but they don't care because you don't know. I mean, which makes anything and everything in a court proceeding unfair. You know, they say, well, this isn't a trial. Well, why am I in court then? Why do I need a lawyer? Why am I in front of a judge? I am trial. Gentleman was telling me about he wants to help this elderly gentleman who got put in guardianship just because he's old, but he's of sound mind and body, takes care of himself, But somebody in the family that's younger decided he didn't need his money, so he's being put in guardianship minus the presumption of innocence. He has to prove now that he is of sound mind and body, that he's been taking care of himself, and nobody has to prove that he can't. The presumption of innocence is gone, an immediate presumption of guilt. But the presumption of innocence is rarely there, no matter what court you go into. You know, there's no due process for the elderly or any minors. I seen where this minor was talking, and she said that they told her just sign this paper, and you won't have to go to court. She signed it, and they took her to juvenile lockup, and she had to spend some time there, months, years, I don't know. But she was saying, so I may be a kid, but I seen TV. Isn't there supposed to be like court hearings and lawyers and judges? They just locked me up. So they told me I signed this piece of paper and I didn't know what it was. She didn't know that she was waiving her rights. Okay, so remember, this is part of the oath. When they took the oath, you know, they took the oath to do what's in the interest of justice. That's part of the oath. That's part of one of the things. That's what all my videos are telling you, what's required of the oath. Okay, and this is one of the requirements of the oath, doing what's in the interest of justice. And again, my apologies, just because I read this and knew about this, and I take for granted that I didn't socialize too much growing up. You know, I didn't have friends in grammar school. I had 2 in high school. But books were my best friends. You know, the older I got, the more interested I got in reading the law. And I just took it for granted, so did everybody else. Especially when it came to finding out what this due process thing. When I read the Constitution, first read it, what was it, in 71? I set myself on a quest to find out what it was. And I knew the rest of that wasn't happening. I had to find out what due process was, effective assistance to counsel, etc., etc., you know. I just had to find out. And that's what I'm teaching you, or telling you about. Actually, I can't teach you. My reading it to you does a whole lot of, not going to do a whole lot of good if you aren't using the information and looking it up for yourself, because I don't want you to believe me. I want you to believe your eyes. Believe in you, in yourself. You know, and once you read what you read, you'll know what you know. Nobody can ever take it from you. It'll sink in just like it did with me. All right, number peace and love to you, folks. May your Creator rain many blessings, and may you have a long life and good health.